I recall when I put you into custody, did we set an exam? Is that what we
Yes,
did
exam is on the 8th.
before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have the file up, Your Honor. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the two ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because I don't know. Did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get. There was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Where is that case? The judge's voice cuts through the courtroom, sharp and immediate. Don Lee sits in custody, already having pled guilty to a minor driving offense, waiting to be sentenced. But something isn't adding up. The judge stops mid-sentence. He remembers signing an order that sent this man back to jail based on a felony case that was supposedly coming down any day. Now, days later, that case is nowhere to be found. He starts asking questions nobody in the room can immediately answer. I'm not going to be very happy right now. The judge warns and the room goes still. Nobody knows what happens next. By the end of this video, you'll understand exactly how a person can legally sit in jail for a crime that was never actually charged. The hearing took place February 10th, 2024, on Michigan Road near Moon Road in Pittsfield Township, Washtenaw County, Michigan, inside the 14th District Court. Don Lee stood charged under MCL 257.326, allowing an ineligible person to operate a motor vehicle, a misdemeanor carrying up to 90 days in jail and a 100 fine plus court costs.
It's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind. But
Yes.
you signed an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you
No.
to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
of your own free will because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
He was represented by Assistant Public Defender Natalie Pate. The prosecution was handled by the Washtenaw County Prosecutor's Office. Appearing on behalf of the people, the the presiding judge accepted Lee's guilty plea to count 2 after a co-defendant charge was dismissed and the matter proceeded toward sentencing. Before any of this, Don Lee was simply a man already navigating the court system, already carrying 2 separate pending felony matters, already living under bond conditions that don't pause for a job, a family, or a paycheck. Pleading guilty to the misdemeanor should have ended his day in court. Instead, he stayed in a cell. Every additional day in custody meant lost income, lost time with family, and a bond that had quietly been raised from personal recognizance to $15 on his existing felony cases, not because of new evidence in those cases, but because of a separate case that, as it turned out, didn't legally exist yet. For a man without institutional resources, that kind of unexplained detention isn't an abstraction. It's rent unpaid, work missed, and a presumption of innocence that exists on paper but not in practice.
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
The justification on record was straightforward enough on its face. Prosecutors had represented to the court that a new felony, related to fleeing and eluding, tied to a separate incident, was in the process of being authorized against Lee, and the judge adjusted his custody status accordingly, remanding him rather than releasing him.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the 2 cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie, for the people on behalf of talking about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
most viewers watching this hearing would have taken that representation at face value the same way the judge initially did when he made the decision weeks earlier. But buried in the exchange that follows is the detail that matters most. Nobody in the courtroom that day could actually confirm the case had been filed.
Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I can't say for sure, may have kept him in custody. Which is why I did what I did.
It had only been signed off by a magistrate, a status that sounds official, even final, but carries no independent legal weight until a charge is formally authorized and the defendant is arraigned on it. That distinction matters because pretrial detention in Michigan requires an actual charging document, not an anticipated one. Holding someone in custody on the expectation of a future felony without probable cause established and entered on the record runs directly against Fourth and 14th Amendment protections against unlawful detention, the guarantee that the government cannot deprive a person of liberty without due process and a documented legal basis. The question the judge was about to force into the open, in real time, in front of everyone in that courtroom, was simple and uncomfortable. Had Don Lee been sitting in jail on nothing at all, what followed wasn't a traditional cross-examination of a witness. It was the judge interrogating his own court's process, live, on the record. He pressed the assistant prosecutor for the police report number. He asked when exactly the case had been signed.
Related to fleeing illegal charges, dated incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
He asked, pointedly and repeatedly, why Lee hadn't been arraigned if the charge truly existed and had been authorized weeks earlier. Piece by piece, the answers collapsed under their own weight. The incident had been signed off by a magistrate on September 30th, but when the court finally pulled the actual log notes, they told a very different story. No probable cause had been found.
Done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me into custody. The prosecutor's office, I think, was given the representation made to this court, was under an obligation to contact this court immediately upon notification.
There was no travel authorized. There was, in the judge's own words, no case. In real-world terms, that meant a man had been sitting in jail for days on a phantom charge, and the office responsible for prosecuting him hadn't told the court it had fallen apart. What should have happened here is not complicated. The moment prosecutors knew the felony had not been authorized, they were obligated to notify the court immediately, because someone's liberty was directly at stake, and that obligation doesn't wait for convenience.
Cost of $250, those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery. The conditions will remain. They never left. It's just they took his liberty on something that didn't get authorized. You're going to be free to go.
I'm going home today.
You're going to be let out, sir.
Thank you.
That single failure to communicate is exactly what the judge zeroed in on, and it's worth admitting plainly, most people assume that once a prosecutor tells a judge, charges are coming, it's only a matter of paperwork catching up. It isn't. Until a magistrate actually authorizes a charge and an arraignment takes place, no charge legally exists in the eyes of the court, and no one should be held in custody on the promise of one that never materializes. Both sides had little left to argue once the record was laid bare. The defense simply asked that Lee be sentenced to time served, noting he'd already spent days in custody on a case connected to nothing. The prosecution had no meaningful counter once the log notes confirmed no probable cause had ever been found. The open question hanging over the courtroom was whether the judge would simply move on and quietly correct the paperwork or hold the system accountable for what had actually happened to a man's liberty. The ruling came fast, and it came with visible frustration behind it. 90 days suspended on the misdemeanor, all fines and costs waived in their entirety, Lee's personal recognizance bond restored on his remaining felony matters, and an order for his immediate release from custody that same day. This reflects the same due process principle at the heart of nearly every wrongful detention case in American law, the idea that liberty cannot be taken or kept on the strength of an assumption rather than an authorized charge. This case is a reminder that the presumption of innocence isn't just a phrase lawyers recite. It's a legal requirement that collapses the moment institutions stop checking their own work. A man sat in custody not because he committed a new crime, but because no one confirmed that a new crime had actually been charged. That is the exact gap where injustice quietly lives, unnoticed, until a judge happens to ask the right question out loud. Next time, we look at what happens when a bond decision itself becomes the subject of appeal, and whether judges have any real, enforceable check on prosecutors who overstate their case to keep someone locked up. Was this one office's isolated failure to follow up, or is it evidence of a system where prosecutors face zero real consequence for representations that later turn out to be false? And if it's the latter, what would meaningful accountability actually look like?